Well, thank you so much for all joining us here this evening. I'd like to start tonight's event by inviting each of you to make first some introductory remarks.
Very well. Thank you very much, Amy. Good evening. My name is Edward Faulks, and as you've heard, I am a practicing barrister. But I also had a foot in the other camp because I was a minister for 3 years in the, first of all, coalition government and then the Conservative government, a Minister of Justice. And that gave me a chance to see the whole question of law and politics in a particular way. During the 3 years, rather controversial years, I have to say, the Ministry of Justice had a number of ideas which they thought would make good policies. The advice we received from civil servants was, as one would expect, professional, thorough, but it always contained a great deal of analysis of the susceptibility or otherwise of every policy to judicial review. There was not a single policy whilst I was in the Ministry of Justice which was not either the subject of an actual judicial review or a threatened judicial review. It was mostly the latter. So I was aware of how politicians are sometimes frustrated by what judges do. Now, many years ago, when I was an undergraduate here, I bought a book called The English Judge. It was a very tedious book indeed. It contained no more than an anatomy of the judges. They were almost entirely male. It described where they'd been to school, which college they'd been to at Oxford or Cambridge, and it was usually Oxford or Cambridge, and their military service, if any, and there was quite a lot of that. It didn't say very much more. It certainly didn't discuss their politics. A rather more interesting book by Professor Griffiths, The Politics of the Judiciary, caused a big storm, however, shortly after it, in which he began to suggest that perhaps judges did have political views, and in some way, those political views might affect the decisions that they made. It was suggested that they were rather small c conservative, possibly rather large c conservative as well. They were interested in preserving property rights. They were interested in the status quo. Not altogether surprising. Most of these judges had served their country in the Second World War. They had a stake in all the establishment organizations with which you are familiar because they still exist. How then did we come to the position where these remote, respected figures could be described by the Daily Mail as enemies of the people? Well, of course, that's a bit of journalistic license. But I'm afraid the relationship between the law and politics has rather deteriorated over the years. If you asked judges what they thought of politicians, what would they say? They would probably say they were intellectually rather low grade, driven by personal ambition, ideological or populist. And if you asked a number of senior civil servants, they might, very privately and discreetly, of course, rather agree with that. What about politicians and their view of judges? Well, of course, as you may have read, a lot of politicians are always suggesting that judges are just grown-up activist lawyers. And what they're doing is frustrating the business of governing. They don't have proper respect for parliamentary sovereignty, and they do not fully understand the complications that are involved in governing. And they come to decisions based on their own idea of what will be a better decision. And I'm not sure that one could comment on who is right about this, except to say that one or two judges have even admitted that they are not, and I quote one former of the Master of the Rolls, very executive-minded. Now, a lot of politicians have been complaining for quite a long time about judges. Will you forgive me if I just read an extract from the report which we produced on administrative law, the IRAL. I described there as nothing new in this debate. In the 1990s, the Conservative Home Secretary, Michael Howard, was highly critical of various judgments. In 2003, the Labour Home Secretary, David Blunkett, concerned at the rise in immigration cases, poured scorn on named judges and deplored unaccountable and unelected judges usurping the role of Parliament, setting the wishes of people at naught and pursuing a liberally, politically correct agenda of their own. So it's not just this government. And then in 2011, Jack Straw, a former Lord Chancellor, said this: "There is plainly a lack of mutual confidence between senior judiciary and this place in respect of the role of the senior judiciary and the broadening authority into areas that are inevitably political." So there is potentially a clash. Now, the Enemies of the People headline, of course, came as a result of Brexit. I remember going to Cambridge to address the Administrative Law Bar Association just after Brexit. Nobody quite knew what was going to happen, but I said I thought it was very, very likely that the process of Brexit would find its way into the Supreme Court. I was wrong. It went there twice. And the first occasion resulted in this headline, Enemies of the People. In fact, it was the lower court that were described as Enemies of the People. It eventually went to the Supreme Court, and you may remember the decision was taken that before the government could invoke Article 50, it was necessary for there to be an Act of Parliament. More controversially was the second case, which I'm sure you will remember, a magnificent constitutional occasion, a hearing before the Supreme Court. Was the Prime Minister entitled to prorogue Parliament? Here was a battle of power, a quite extraordinary business. Clashes of power all over the world take place with tanks, with demonstrations, with murders. This took place with a decorous argument in the Supreme Court, the finest legal minds addressing the finest legal minds. Unfortunately, in my view, they came to the wrong conclusion. That doesn't, however, in any way deprive the importance of this process, which involved a careful consideration of whether the Prime Minister had acted unlawfully or not. Quite a big thing to conclude that the Prime Minister had broken the law. But I'm sure some of you will remember the sight, and it was important that there was a woman sitting in the middle of the court, the famous spider brooch, pronouncing in no uncertain terms that the Prime Minister's decision to break the law by proroguing Parliament without providing a proper justification meant that he had to think again, that Parliament had to be reassembled. Is this the reason that the government decided to set up the Independent Review of Administrative Law? It certainly might have been a factor. There have been a number of other decisions which people have not been very pleased about. Time does not allow me to go into these. But before you will be persuaded, no doubt, by distinguished academic and distinguished judge about how judges are almost infallible and how the rule of law must mean that we should never even question the decision of a judge. Bear in mind that politicians are elected, judges are not. Politicians are doing their best to muddle together the compromises that have to be achieved, as indeed Jonathan Sumption pointed out so forcefully in his Reith lectures. And bear in mind that describing them as enemies of the people might be overdoing it a bit. But there is a real and serious question that judges sometimes overdo it. Thank you very much.
To answer the exam question, are judges enemies of the people? They are the heroes of the people. Why are they the heroes? Well, to me, it's just yesterday. But in the 1960s, when I cavorted and performed in this very chamber, it was virtually impossible to challenge the exercise of any discretionary power, certainly of the executive, never of the Prime Minister, and of most public officials. Judicial review was just not there. Thereafter, the judges fashioned the common law, probably one of the greatest signal achievements in the common law over time. Now, Edward, none of us agree with judicial decisions all the time. We're all made of crooked timber, including judges. But the question is whether some high-profile cases which have held against the government, Miller 1, Miller 2, a couple of others, trespass on the proper role of government, and if so, whether that merits Parliament coercing or directing the development of our common law. Is it for Parliament to do that? I think it's a constitutionally dubious path to take, because it infringes the bedrock of our democracy, namely independence of the judiciary and the separation of powers. What a wonderful endorsement of our democracy it is that the Prime Minister can be held to have acted unlawfully. That wouldn't happen in many countries today that are either in the camp of despots or moving in that direction. And this is a real issue. We're not debating an academic issue. Even over the past few weeks, there have been threats to intervene on the part of those in high office. Although I have to say that Lord Faulks's report, the Independent Review of Administrative Law, I think took a very balanced view of this question. So let me first ask a slightly academic question, but I think it's part of the constitutional background that one must address, which is, what are the respective roles of judges and politicians? Or politicians or the government have the role of making policy. There can't be any question about that. And judges have the role of applying the policy, the exercise of that policy, and of doing so in accordance with principle, including constitutional principle, even in a country that doesn't have a codified constitution. And those of you who have studied the works of Ronald Dworkin would know that he makes that distinction between policy on the one hand, which he calls utilitarian calculations, the greatest good for the greatest number, that is for the elected politicians, and on the other hand, principle and the application of the law, which is for the judges. And so it's for Parliament to decide whether to build a new airport, and it is Parliament decide whether to raise the minimum wage. But whatever we may think about parliamentary sovereignty, and there are many that hold to that principle with almost fanatical religious fervor, we do not live in a country where majority rules without checks and balances and restraints, such as respect for equal human dignity, for free expression, and so on. And anyone who knows anything, as you all do, about the excesses of popularly elected governments in Germany and Russia in the 19th century know that the kind of the kind of excesses that pure majoritarianism can achieve is not the kind of democracy that we would like to live in this country. So turning now to the role of the courts, that is a mediating one. It is to guard Parliament's purposes and intent and ensure that the policy is lawfully implemented and properly justified with due regard to the equal respect of those who are actually affected by decisions. The grounds of judicial review are that the decisions of all public officials from the Prime Minister down should be lawful, procedurally fair and rational. And we no longer live in a country where the prevailing culture is one of authority, but we've moved to a culture of justification. And this is the Miller 2 case. The Prime Minister prorogued Parliament for 5 weeks. It ought to have been getting on with urgent business. He could not properly justify that decision. He took into account, it was thought, considerations that were purely, he was the one who took into account the purely political considerations, forgetting the legal aspects that were required for that decision. Another quick example. Until recently, none of our prison population had the right to vote. Our courts, in hearing a case by a prisoner seeking a right to vote, held that it was not for them to have a right to vote. It was part of their punishment not to vote. The European Court of Human Rights, much maligned, disagreed and said that at least some of our prisoners should have that right. The Prime Minister at the time, David Cameron, said that this was the court there, the European Court, was interfering with policy. And he said, Having prisoners voting makes me feel physically sick. This is what I call the digestive school of jurisprudence. An example of that, if you read the judgment, you will see that the European Court, by no means second-guessed our government on policy grounds. They said that at least some prisoners, there shouldn't be a blanket ban, but at least some prisoners should have a right to vote. And indeed, in our jurisprudence too, prisoners do have certain rights, except, of course, the right to be totally free. They cannot be tortured. The prison officials can't interfere with their correspondence. They must have access to the lawyers, and so on. It's not entirely revolutionary. There's a perfectly good argument of principle, not of policy, that prisoners should have a right to vote. So there you see starkly the kind of atmosphere that we're in. Of course governments don't want to be overruled by the courts. Of course they want to have their way. Of course they want to not be impeded and move on with the delicate and difficult job of governance. No official wants to be overruled. But how good it is that they should think, as your public officials did, Edward, to think about, is this going to be lawful? Could this somehow be contrary to an important principle of our democracy? And then finally, I just want to put this in an international context, because we mustn't innocently believe that this discussion can be insulated from the present existential threats to democracy as a preferred means of government. United Kingdom administrative law has served as a model for constitutions worldwide. You look at the South African Constitution, Section 33, all governance must be fair and reasonable and lawful. Exactly our grounds of judicial review incorporated there. Other countries too have accepted those views. Our judges are hugely respected worldwide. So any perceived reduction of our commitment to our system of constrained democracy and legal accountability and judicial independence plays into the hands of democracy's doubters and outright foes. Thank you.
Well, thank you, and thank you, Geoffrey, for defending my profession. There's not much left for me to say, actually, after that. But first of all, I mean, it's an extraordinary honour to be here. I've never been in this amazing room before. I was at the rival establishment on the Fens. I never took any part in either politics or in union debates, and so it's quite an excitement to be a part of this show. As far as this evening's discussion is concerned, I think the best I can do is to give a sort of personal view from someone who is actually a judge. I've been a judge for over 25 years, but I was involved in both the Brexit cases. And I mean, one thing to say about them both is actually, when we come back to this, they didn't actually have any practical effect at all on what thereafter happened. They were very exciting at the time and people got very interested, but actually if you ask, did they make the slightest bit of difference in terms of practical politics? Answer, no. But at the time they seemed important. The first one, as you know, the court below had been castigated as enemies of the people for deciding against the government and deciding that this issue should be put back to Parliament before the notice was served on the European Union. When it came to us in the Supreme Court, we decided that we had to sit as 11 to sort of show that there weren't any sort of biases. But the Daily Mail attempted to analyse us in terms of whether we were sound or not, or whether we were dangerous Europhiles. I came out as a 5-star dangerous Europhile, partly because I have an Italian wife, which, there we are, partly because I'm a lover of European culture, they said, which I am, and partly because I played the viola, which I do. and on that basis, it was assumed I would be voting against the government. In the end, I actually was one of the dissenters. I was one of 3 dissenters. Having heard the arguments, I took the view that Parliament, having authorised a referendum on the question of whether we should stay in Europe or not, and we having decided that we shouldn't, it must be implicit in that the Prime Minister could at least start the ball rolling. But I was in a minority of 3. But I'm happy to say, was billed by the Daily Mail as a champion of the people. They had photographs of the 3 of us, champions of the people. So I hope they remembered that when we came to the second Brexit case. I don't think they did. The second Brexit case, I think you've got to remember, I see all these cases from the point of view of a judge who is not political. I was a professional judge. One has to decide the case as it comes before you. And in that case, I first heard at the end of August that the government was being threatened with possible proceedings in Scotland over rumours that it was going to try and prorogue Parliament. And at the time, the government denied that it had any such intentions, but it turned out they did. And so, anyway, it then became apparent that there was going to be proceedings in England. And we were warned, I was in Italy at the time, that we'd probably have to come back and sit urgently. My initial reaction was, well, it's mad to try and decide a case of this importance, constitutional. It was a completely novel issue. Can the courts review a decision to prorogue Parliament? To do that in what would have to be 2 or 3 weeks to make any difference. And so I rather hoped it wouldn't happen. And I hoped to be able to continue my holiday, but that was purely a personal point of view. Anyway, as it turned out, there was a parallel cases in England and in Scotland. And in due course, in early September, they were decided in different ways. The English Divisional Court decided that it was not justiciable. The courts couldn't look into that question. The Scottish Court of Session decided that you could, and the government should be had acted unlawfully, and the prorogation was of no effect. So at that point, it became quite apparent that we had to sit. We couldn't sort of leave this issue with 2 parts of the country deciding on an issue which affected the whole of the United Kingdom. So there was no doubt then we had to sit. And we had to deal with it very quickly for it to make any difference. And trying to get together a decision of that importance with the advocates preparing their very substantial briefs, sitting 11 of us, I do think we got not enough credit for the sheer physical achievement of getting that case on in a matter of a couple of weeks and getting the decision. And I must confess, when I went into that hearing, I thought the Divisional Court's judgment saying that it was not justiciable because it was a political decision and outside the realm of the things the court should be looking at, I thought that was pretty convincing. And I certainly was quite prepared to decide that they were right and we couldn't do anything about it. But again, you've got to remember that as judges, you deal with cases on the arguments that are put in front of you, on the evidence that's put in front of you. And that was pretty sparse, to be honest with you. I mean, the government didn't attempt to justify the decision to prorogue. It was quite clear that it was longer than was necessary to do what the normal thing of preparing Queen's speech, preparing for the new Parliament. But they didn't attempt to give any reason for it. Indeed, on the evidence before us, it was said it had nothing to do with Brexit, which I must say seemed a bit rich, but we have to deal with the cases that's presented to us. And we also, the Prime Minister didn't help himself because he has a certain way of doing things. And I don't know whether any of you read the judgment, but there was a sort of note from one of the officers in the Parliament saying why, in fact, proroguing Parliament wouldn't make a lot of difference because there would be party conferences anyway, so there wouldn't be a lot going on in Parliament. And there was a sort of scribbled note from the Prime Minister on the bit of paper. Yes, Prime Minister's handwritten comments on the memorandum. They read, 1, the whole September session is a rigmarole introduced by that girly swat David Cameron to show the public that MPs were earning their crust. So I don't see anything especially shocking about this prorogation. As Nicky notes, it's over the conference season, so the sitting days lost are actually very few. Now, the bit about that girly swap David Cameron was actually redacted from the papers in front of us because it was no doubt thought embarrassing, but it came out in one of the newspapers, so there we were. But I mean, of course, that in a way doesn't answer the legal question, but it certainly doesn't make you very keen to sort of go along with that particular decision. But obviously that didn't affect me in any way in my legal analysis. But I think the other important point, which people have rather missed, is that a lot depends on the way the people choose to argue the case. Now, the thing that really I thought was most difficult about the case was that really we were dealing with the relationship between government, the Queen, and Parliament. Now, the decision to prorogue Parliament is the Queen's. She does it on the advice of the Prime Minister, but ultimately it's her decision. And back in the days of Queen Victoria, she'd come into Parliament and do it personally. Now, under our particular monarch, she has taken a particular position. She hasn't got involved in any of those things. But I was quite interested to know what the form was. And we had a very interesting briefing paper from someone in Parliament about the prorogation and discussing, the whys and wherefores, and making the point that actually in some Commonwealth jurisdictions, the governor, as representative of the Queen, has on occasions made quite an active part in trying to persuade the Prime Minister not to go ahead or to get the views of the opposition and so on. So I asked questions about that, and it was made quite clear to us that we were, by both parties, including the government, that we were to proceed on the basis that the Queen had no choice other than to accept the advice of the Prime Minister. So there you come down to actually what's a much simpler question. If this is simply a decision made by the Prime Minister, forget about the Queen, forget about all the flummery. Why should the Prime Minister's decision not be reviewable? We're not, just as in the first Brexit case, Mrs. May's decision to launch the notice to Parliament. No one suggested that wasn't reviewable, even though it was a heavily political decision. But it was a decision by a minister, and that's what courts do. So, I mean, once that was out of the way, then it seemed to me that actually the rest was relatively straightforward. I mean, there are lots of issues, and the judgment, I thought it was a very impressive judgment produced by Brenda Hale and Robert Reid in the course of 3 days. And I was able to go along with that. But I mean, if we'd had to go into those, to me, much more difficult questions, then it might have been a different thing. Just as a footnote to that case, my wife was rather cross that we missed out on some of our holiday. And so I got Brenda to agree that I could go off to Sardinia immediately after the hearing. And we would then get the judgments. You'll see this in her memoirs, actually. She's just written her memoirs under the title Spider Woman, which is worth reading. And anyway, so the idea was that they would write the draft judgment, and then wherever we were, we would get it and get back our comments by that Sunday evening. And my wife was rather cross at me spending the Sunday reading this judgment and working on it. Took a photograph of me with the laptop in front of me and the Mediterranean in the background. And she sent that to Brenda just to say how hard her husband was working. Anyway, Brenda mentions it in her book, although she says it's Sicily, not Sardinia, but it's actually Sardinia. Anyway, I remember being enormous on the Sunday morning, getting the draft and being worried that it would be, I either wouldn't be happy with it or I'd want to write a concurrence. By then I was clear that I was going to decide I was going with the majority. But happily, I thought it was a brilliantly prepared judgment. It was quite succinct than it had to be. And I made various suggestions which were taken on board. And so she was able to deliver it 2 days later. But it was a remarkable achievement by her and I think by the court. And I'm certainly very happy that on the way the case was presented to us, it was the right decision. So thank you very much.
thank you all very much for those introductory remarks. I'd now like to put a series of questions to the panel to discuss before we invite some questions from our audience members. So my first question to kickstart this discussion is, so earlier this year we had the Independent Review of Administrative Law led by our guest speaker, Lord Faulks. Since the report has been published, it's been pointed to by individuals across the political spectrum, both to support arguments in favour of curbing the power of judges, or to argue concerns have been overhyped. In light of the content of the report, do you think there are reforms that need to be made to judicial review in the UK?
Yeah, we recommended one or two, two quite substantial reforms which involved reversing decisions of the Supreme Court. We did not think, however, that there was a case for completely dismantling judicial review. We thought it was a very important part of the rule of law and part of the checks and balances that exist in our Constitution. But we did make the point, I think forcefully, that parliamentary sovereignty, although I don't want to fetishize parliamentary sovereignty, I'm sure Jeffrey would not like me to do that, does mean that if Parliament doesn't like a decision of the court, after careful consideration and given the restrictions on legislative time, it can pass acts which reverse the effect. Of course, it can do that with its own acts. No Parliament can bind its successor. So we thought those were sensible suggestions. We made one or two procedural suggestions. The government didn't like the report very much because it didn't go far enough. They wanted a bit more red meat in it. But we approached our case independently, approached the project independently and I think conscientiously, and we didn't think there was any red meat to offer up, I'm afraid. Initially, they were going to produce a lot more reforms than we had suggested, but in fact, the bill, which had its second reading in the House of Commons yesterday, and I'm sure some of you have already read Hansard, has in fact really more or less done what we suggested. So modest reforms. I think the new Lord Chancellor will say these are reforms we can build on, which was rather sinister, but these are the reforms. Otherwise, he's not as happy as he might be. But yes, I think no area of law does not deserve change, review, and reform. And suggest that somebody did that our whole exercise was a constitutional vandalism, I thought was ridiculous. Our Constitution should be examined from time to time, and it can do with the examination just like any other area of the law.
I think, I've said already, I think it is a balanced report. And the fact that you've endorsed judicial review as a whole, I think, is commendable. I think one has to be very careful. As I said, one mustn't be too disingenuous about all this, because there are many people in this country, not referring only to politicians, I'm referring to academics, I'm referring to the Judicial Power Project and other places, who are vaunting the notion of parliamentary sovereignty, trying to build it up, in my view, to a doctrine that brooks virtually no interference and is not tempered sufficiently or at all by the notion of the rule of law as a constraining influence. If you go back to Dicey in the 19th century, his genius, I think, was not only not really to say, parliamentary sovereignty. That was pretty obvious in those days. Finally, we reached representative government. Of course, the representatives of the people. Of course, there were no women in those people. There were mostly aristocrats who had the vote at that time. But nevertheless, the people ought to rule. But he also said, my other principle is the rule of law and an independent judiciary and civil liberties. And if you move from France to this country, you move out of despotism as it then was to freedom and democracy, and there should be a presumption of freedom and rights. That was Dicey, if you look carefully. And it wasn't only about parliamentary sovereignty, which a number of politicians now depict him as being. So that's the context. So we mustn't be too naive. And I think, Edward, as much as I do admire your report, I think occasionally you say things like, of course, Parliament can do this if it wants. You can do anything if you want to. You can ban smoking in the streets of Paris if you like. Another exam question to many law students here about the British Constitution over the years. But maybe you should just perhaps worry a bit about striking down decisions through a quashing order and don't apply them to the person who's applied to the court, and this is the bill that's going through at the moment, and make them prospective to come into effect, for the benefit of other people, but not the person who has actually brought this case. That terrible danger there even, there are arguments in favor of it, but a danger there, and that's part of this bill, that it will chill the effect chill applications to the courts. I mean, why would you bring a case to the court if you knew that there's no opportunity or little opportunity for you to get the benefit of the decision? There may be some civil society organizations that would do so in order to get a change of law. But I think we must be very careful about interfering with this, the structure of administrative law and judicial review at this particular moment in time. And as I said, I won't go over that again, but I do think it is vitally important that we have confidence in our systems and show confidence in our systems of democracy at a time where democracy worldwide is under very serious threat. And I'm not only talking about developing countries and some Eastern European countries who used to be part of the Soviet Union, Russia, Poland, Russia, and Hungary. There are other Western democracies that are perhaps sliding in that direction too.
Yes, I agree with Edward. In fact, it's not entirely coincidental that the recommendations his report made are very similar to recommendations I made in a lecture I gave a year ago to the Bar Reform Group, which I think he might have read, but I'm sure there's a lot of independent thought went into everything he did, and I certainly agree with it. Funnily enough, the thing that nothing which I find very odd about the whole debate was that although it was said to have been triggered by our second Brexit case, the one thing no one discussed was whether the court should be able to review prorogation. In my response to the government's paper following Edward's report, I had a little section called "The Elephant in the Room," because it seemed to me, as this whole thing had been about the relationship between the courts and sort of parliamentary processes, someone might have looked at that. Because, I mean, I noticed last week, I don't know, you may have seen a lecture by Suella Braverman, our distinguished Attorney General, criticizing our judgment and saying that in terms that it was quite contrary to Article 9. She said, questions around the prorogation and dissolution of Parliament fit squarely within Article 9 of the Bill of Rights. In my opinion, it's clear that on a plain reading of Article 9, the conclusion of the court is not supported. Well, I'm slightly disappointed that no one pointed out to the Attorney General, or that she didn't discover herself, that it wasn't argued before us that it had anything to do with Article 9. And it didn't. I mean, there was a question about Article 9 which came up on the question of remedy, but no one suggested that the Prime Minister's advice to the Queen was a proceeding in Parliament caught by Article 9 of the Bill of Rights. Now, in some ways, it would have helped us an awful lot if we'd had an up-to-date statute or something, slightly more up-to-date than the Bill of Rights from several centuries ago, which actually defined the relationship between Parliament and the courts, and it would have saved us a lot of trouble. And for my part, I can see nothing wrong in a statute which says, well, prorogation shall not be justiciable. But we didn't have it. But it does slightly surprise me that no one seems to have thought that that might have been the natural response to dissatisfaction with our decision. So I just throw that out. Maybe someone here will pick it up and have a word with Suella Braverman so that she realizes that she's got the wrong point.
Thank you. So looking at some of the other kind of key political figures who have commented on the role of the courts, the Lord Chancellor Dominic Raab has recently proposed a mechanism for the government to introduce ad hoc secondary legislation to correct court judgments that ministers believe are incorrect. Do you think this suggestion is a suitable approach to court decisions that the government think are wrong?
No.
Try to go fast.
No, I don't, Fred, I don't think so either. I'd like to be able to defend it, but it seems to me that whilst accepting that decisions can be reversed, the idea that you have an annual roundup of decisions that you don't like and you put them in that box to be reversed automatically by Parliament is not properly reflecting the respect that we need for the judiciary, for the rule of law, for the independence of the judiciary. No, I think that's constitutionally very, very odd and very unsatisfactory. Sorry to agree.
I agree.
Oh, well, a very clear answer on that particular question. So looking at some other of the key players in the legal process, it's been suggested that we're seeing an increase in litigation that seeks to use judicial review to achieve certain political ends, often through, say, strategic cases brought by activist groups. Do you agree with this perspective that we're seeing a rise of this type of litigation? And do you think the courts are adequately equipped to kind of deal appropriately with that?
I think they're equipped to deal with it. Certainly they're equipped. And in fact, one judge said that they were astute to identify cases that were politics by other means. However, the identifying what is politics by other means and what is a genuine legal dispute isn't that easy. And people are entitled to challenge decisions, whatever their motives. You don't look into their souls, as it were. But when you have particular organizations who say our main message is that we are going to pursue our political aims via the route of judicial review, it is legitimate to ask, is this really what the court should be about? It should be about determining disputes, not furthering or even stopping a particular view. So I think the courts have got to be aware of this tendency. And there are certain instances where I think the courts should be challenging the standing of people to bring claims rather more astutely than they do.
I believe that the role of these bodies, NGOs, civil society organizations, pressure groups, is increasing, ought to be increasing. I think of people who came aboard the Windrush to this country some years back. And then they were told, after a series of mishaps, many years here, settled their roots, that since they could not prove their identity, it wasn't given to them when they arrived, they had to go back to the countries from whence they came. An outrageous incident. We ought to be deeply ashamed of what happened there. Read Amelia Gentleman's book. She was the Guardian journalist that raised all these questions. It's a complete scandal. If only there had been one of these organizations then to take up these cases, to look into it for the people that were trying to object, to protest, had no mechanisms to take their cases forward. They had no money to do so. Many of them were already out of this country, back where they came from, without any roots there whatsoever. Think of the people who were involved in the recent post office scandal. Perhaps not a public law case, but perhaps it is. All these postmen and women who were accused of fraud, very recently this, and were dismissed from their jobs, lack of livelihood, no one to help them. Eventually, they banded together, managed to have their cases looked into. Perhaps it was by judicial review, perhaps it was by some other mechanism, but certainly why not judicial review? Think of the water, the sewage that has been poured out, very relevant this week, into our rivers over the last years through exemptions that were abused, clearly abused in many cases, allegedly so anyway. But one has seen the rivers of this country, many of them simply die because of that kind of abuse. Had there been a body that could have brought those cases on behalf of individuals who didn't have the resources or the know-how or knowledge of environmental law, so much the better.
Well, I mean, the only point I'd make is I don't think this is new. I mean, when I was a young barrister in the 70s, I was doing cases for people like Shelter. I remember doing a case of Child Poverty Action Group when in those days inflation was running at sort of 20%, seems strange now, and there was something called the benefits uprating order, which was meant to be uprated each year. Benefits were increased to keep up with inflation. But under Mrs. Castle, I think it was, as Secretary of State, they did a very clever trick, whereby they managed to miss out 6 months by changing the date for the uprating. And they missed out 6 months when inflation was its highest. And we brought a case against Mrs. Castle for a declaration that this was all unlawful. And we had a good run. We lost, but it was, it was certainly, there's nothing new about this. I mean, and we had some very interesting cases. And but I think they played a very important part. And I think, but Ed was absolutely right that they need to be very carefully done. And I think the best organizations are the ones who use litigation strategically for particular purposes, but don't overuse it. I mean, I've been quite heavily involved recently in sort of actions about the environment and climate change and things like that. And I think, take one organization, Client Earth, I think they're brilliant at the way they use litigation in a very targeted way in different systems, but very much as part of a general campaign. And I think there's a real role for that. But I certainly don't think it's not new, and I think it will continue.
So would you agree with Lord Faulks' approach that the courts may want to scrutinise more heavily the standing of those bringing cases, or potentially alternatively bringing other limits on who could bring those type of cases and their motivations? Or do you think that's sort of beyond the scope of the courts?
No, I mean, I just don't think it's a new thing. I mean, I think we've all, I sat as a judge of the Minister's Court for quite a long time, and we had some cases which were quite undeserving, and you tried to shut them out. But ones that can't always discriminate, and I think there's a big problem with the delay of litigation. I mean, particularly in the planning development field, where you've got to deal with things quite quickly. But I don't, it's not. There's no easy answer. But I don't think it helps for government to start laying down rules. I think the courts should be allowed to get on and do their job.
So the final question I'd like to ask relates to the questions surrounding ouster clauses and how this relates to the debate surrounding the appropriate balance between the courts and Parliament. So I'd be interested to hear your perspectives on whether Parliament, in your opinion, could ever legislate to wholly exclude the courts from reviewing a decision of a political decision maker. So, for example, the draft bill to repeal the Fixed Term Parliament Act that was referenced earlier contains a so-called super ouster clause that purports to make the exercise, limit and extent of prerogative powers to dissolve Parliament completely not reviewable by the courts. Would this effectively oust the courts, or do you think we would see the situation that we have in other cases where the courts often find creative ways to still introduce their review?
I'd like to go first because Robert Carnwath is the hero of ouster clauses, so I'm sure he would like to finish up with a resounding speech about this. By a strange coincidence, this morning I was on the Constitution Committee and we were considering this very question of this particular ouster clause and whether it was a sensible way of achieving it, whether it was potentially contrary to the rule of law. I mean, the answer is that the government very much wants to prevent the dissolution of Parliament coming up before the courts because it doesn't know what's going to happen. It always thought that it was non-justiciable, and this goes for all governments, and now it's trying to make it clear after the bruising encounter with the Supreme Court over prorogation. So that's the intention. The ouster clause, I think, as a matter of construction, probably does what it intends to do. Will the courts allow it to? Or should Parliament, in fact, of itself amend the bill and make it more kind of nuanced and allow for certain circumstances in which the dissolution could perhaps be challenged? I think that's rather difficult, actually. But there is always the rule of law, and there is always Robert Carnwath's his obiter comments in the Privacy International case, which were referred to today as the high point of the rule of law in relation to ouster clauses.
Well, I was one of the lead counsel in that case that managed to convince Robert that an ouster clause was against the rule of law. It was a split decision, but I think that's one of the most receptive and brilliant judgments you've ever made. Well done. I played the viola at this point, the viola. And throw onions into the crowd. But it is an onion matter. It is a matter to weep for, because what does an ouster clause say? Are you all law students? Because others may not know quite what it is. So Parliament says we give power to a body, let's say, to build roads, okay? And no decision of that body may be challenged or appealed in any court or tribunal, including about its jurisdiction. So, if the ouster clause were to bite, you would have the body deciding, we're going to build roads this week, next week we're going to make cars, and the week after that we're going to cut down trees in the forests. We're a big enterprise and we're going to make lots of money for the government. We go outside of our jurisdiction. The Act says build roads and you can do anything. Well, so we want to challenge this excess of jurisdiction going out of the four corners of their conferred powers. And we go to the court, and the judges, if they weren't like Lord Carnwath, they would say, no, I'm sorry, there's this ouster clause that says you can't challenge this case in any court whatsoever, even on the ground of jurisdiction. Isn't that a bit rich? Isn't that a bit absurd? How can a body define its own jurisdiction and get away with it? That's the attack on the ouster clause. And there's an ancient jurisprudence, which you'll read in the Privacy International case, which is what we're talking about here, which goes all the way back to the 17th century, saying that a body that has conferred powers, precise powers, cannot define its own jurisdiction. If it goes outside of those powers, then it is acting unlawfully in excess of its jurisdiction, in excess of its powers. It's as simple as that. And the fact that the government is even thinking about restricting judicial review is a great blow for the access to justice, which is one of the key elements of the rule of law.
Well, I'm not sure what to say after that. I think I'm, in a sense, I'm closer to Edward, really, because the particular clause was in relation to the dissolution of Parliament. But as far as I'm aware, it's been clear for donkey's years that the dissolution of Parliament is not judicially reviewable. Certainly there's very high authority to that, and frankly, I can't see any reason why the courts wouldn't respect that, whether there's an ouster clause or not. The problem with prorogation was there was no authority about it, and so we had to make up our minds. But for my money, if there was a bill, an act of Parliament which says that prorogation is not justiciable, that wouldn't cause me to lose any sleep, and I would expect the courts to give effect to it. The Privacy International case, in which the arguments of counsel were particularly brilliant, as I recall, it was an absurd thing, really, because this is a body. The question as to what extent the government can regulate the supervision by the security service and allow people to tap your telephones and things like that. And that's subject to this tribunal called the Privacy Tribunal. And for some reason, the Act said that was not to be reviewed in a court. Now, if ever there was a subject which should be reviewed by the courts, it's a question of interference with someone's private activities. And indeed, after the facts of the case came up, the government did introduce a right of appeal to the Court of Appeals. So in effect, the sort of issue which we were debating in theory had been overtaken by events. But and we weren't making new law. We were applying, as Geoffrey says, a principle which had been laid down in the sort of 18th century and reaffirmed in very strong terms by the House of Lords in a case called Annis Minnick in 1969. So there was nothing novel about it. And again, I was rather shocked that Suella Braverman criticised our judgment without seeming to have noticed that we were actually giving effect to a House of Lords judgment which was 50 years old. So, and in response to the Edward Faulks's review, which the government seemed to think hadn't gone far enough, they did issue a paper in which they said it was terribly important to have effective ouster clauses. But one of the points I raised in my response to that, well, which particular ouster clauses, what are you trying to oust? Give us a situation where the government's been been badly affected by an ouster clause. I mean, Privacy International is not such a case because you in fact introduced a right of appeal in later legislation, and no one's suggesting that should be reversed. And in fact, they didn't come up with an answer at all, and they've dropped that part from the bill. So it seems to me it's a very theoretical argument. You know, if there's a good reason for an ouster clause, then there's no reason why the courts wouldn't give effect to it. But certainly the courts should feel able to look at the circumstances and see whether the ouster clause is truly effective. And the other thing to say about my judgment, I think is rather important, if I can just add this. This was said within the context of the Constitutional Reform Act 2015, Section 1 of which says, this act does not affect the existing constitutional principle of the rule of law. Now that's basic to the Constitution, and it says we're governed by the rule of law. It doesn't define what that is, but implicit in that is that it will be the courts which will say what is the rule of law. And as I said in my judgment in the Privacy International, within that context, the rule of law, the existing principle of the rule of law as understood in this country for the last 300 or 400 years, has involved the ability of the court to say that a clause does not prevent, does not protect a body which is going outside its power. That's all.
Thank you. And so to finish, I'd like to invite some audience questions to our panellists, if anyone has anything they would particularly like to ask. So the member in the front row just here, if you could just wait for the microphone to get to you so we can hear you.
Right, so I was just wondering, going off of what Lord Carnwath said about the importance of groups like Client Earth in environmental law specifically, what are your thoughts on the kind of executive focus of the draft environmental law bill and the kind of apparent attempts to kind of preemptively oust judicial review through the inclusion of lots of executive discretion?
What, are you talking about the current environment bill, which is still going through Parliament? Well, I've been quite confused by that bill because I don't quite understand what it's doing in terms of the role of the court. I think it's not effectively ousting the role of the courts. It includes a role for the courts, but in a sort of slightly, in a specialised way. But I don't think we need to worry too much because it doesn't displace ordinary judicial review, so it doesn't affect the ability of bodies like Client Earth to bring cases, and I'm sure they'll continue to do so.
And the member just here on the end.
A lot of the criticisms of the Supreme Court in the Miller cases were centred around the lack of elected judges and the lack of kind of democratic will in the courts. Do you think either a written single constitution or the, say, election of or political appointment of judges would make these decisions easier, or would that just cause more problems like in America?
I'm not very keen on the idea of appointing judges. The Supreme Court in America does it, and although the judges don't always perform the way that the government that elects them or chooses them expects, I think we should try, insofar as we can, to keep judges away from the political arena. There have been various suggestions that perhaps before appointment they should appear before the Constitution Committee just so that we can get an idea of what they're likely to decide. I think it's a worrying trend if you do that. So I think, notwithstanding that judges are perfectly entitled to have political views, I don't think we should go that way. And as to a written constitution, an age-old question, personally, I think we muddle along the way that we do.
On a written constitution, I think it's just been said, we muddle. It's a bit of a muddle. And if we want to be clear, if we want people to understand, if we want school children to know what our constitution is all about, and people stop saying, what constitution? We haven't got a constitution, and we have a series of very clear constitutional principles, but nobody sort of knows what they are until it's expounded in a case or with the clarity of the two speakers on my left and right in an environment such as this. I think there's a lot to be said for a written constitution. But since we do muddle, I think the last thing that we want is to have it more muddled by introducing political judges that will, particularly those who will can feel constrained to decide in accordance with the party who appointed them. And you see that in the United States with notable exceptions. But I think what's so interesting here is that we've discussed a few cases, and others have been referred to recently as acceptable or unacceptable cases. You take someone like Lord Carnwath on my left. In the first Miller case, he was on the side of the government. In the second, he was not. On Privacy International, he was against the ouster clause. In other cases, I failed to persuade him to act in the way he ought to have decided. And I think that's the beauty of our system. Lord Reid, in the Unison case, held that excessively high court fees impede access to justice. That's on the Attorney General's list. How can you interfere in policy, she says. Well, he did so by saying that, doing a sort of calculation, a statistical analysis, and came to the conclusion that they were actually obstructing access to justice, which is a principle of the rule of law. And this was introduced not through a parliamentary act, but by delegated subordinate legislation by the executive, and therefore was unlawful. But then in another case, he has said in the Begum case, this unfortunate woman who went and joined ISIS, now wants to come back to this country. He said, no, even in a case like that, national security trumps fair procedures, natural justice. Natural security trumps natural justice. That's Lord Reid. And Lord Reid, in the Privacy International case, was on the wrong side of Robert and me. So that's the beauty of our system.
Great. So if we can invite one final question from the audience. So the member just here.
Thank you very much for the insightful discussion today. I actually have two questions, both contradicts each other. My first question is, I do believe that a judicial review is an important tenet of progressive democracies, and especially for courts to have check balance from Parliament. However, in the light of decisions like the prorogation of the Parliament, which I personally don't agree, I agree with Miller 1, which was justified very well, unlike Miller 2, where the issues such as political decisions are considered as justiciable. Where then should we draw the line of that judicial review? Where should we draw the line for the courts? To what extent shouldn't then go on and consider points of Parliament which may not even be justiciable to consider them justiciable? But then an opposing question to that contradicts this whole point is the consideration, should judges do more in terms of considering you mentioned, sir, the Griffin's book on judiciary. There was a similar book by Ellen Peterson, The Law Lords, which brings the whole debate of legal realism, that the judges to some extent are, again, human beings. They have their tacit biases influenced by where they come from. And the question is, law is generally considered a very closed system. We look things through the doctrinal view, but now there's a lot of discussion in the academics that should courts be doing more, giving law more relevance to the social practices that goes on, rather than limiting them to the whole doctrinal view of what the black law is and interpreting that accordingly. Thank you.
I agree with a great deal of what you say. I think the problem is, how can judges make decisions which are quasi-political? When politicians do so, they do so with a mandate from the electorate. They have to accommodate different views. When judges are taking these big decisions, they often say, we can't do this, it's non-justiciable, because we don't have the means in which we can just say whether this is reasonable or unreasonable. So you're suggesting the possibility of some sort of broader inquiry, maybe that they should be taking into account other considerations. In America, they have Brandeis briefs and so forth in the Supreme Court, where they will set out all the socioeconomic effects of a particular decision. There have been times when the Supreme Court and the Court of Appeal have taken in so many interveners that they have almost got to that stage where people are not so much arguing about the law, they're saying this will happen if this happens. The problem is there isn't any way of testing that adequately because they're putting argument rather than evidence. And the political process, and I agree with what Jonathan Sumption says, is imperfect though it is, a far more satisfactory way of resolving big issues. The judicial process is not well suited to the sort of wider inquiry that you suggest.
I would largely agree with that, except this, that in public law, administrative law, judicial review, much of that has to do with political decisions in the sense that there will be politicians who will disagree with the decision because it is their government or their local authority that is overruled in the particular case. Political in that sense. But I rest on what I said earlier, that that's different from saying that the judges may intervene in policy. They inevitably get involved in politics. And those decision makers who are overruled get nasty about them and call them unelected and don't know what they're doing, don't understand the social implications and so on. And there are limits to the adjudicative process, which Edward has outlined. But I rest on what I've said. Policy is actually for government, and principle and the implementation of that policy within the law is for the judges.
Yes, I mean, can I just, I don't disagree with it. I think we haven't mentioned the Human Rights Act in this context, but I do think it's important to bear in mind the extent to which the Human Rights Act, bringing in the Convention, European Convention, which I certainly supported, has thrust us as judges more into the role of looking at political judgments. And the particular area I found terribly difficult is when dealing with arguments about social security benefits and whether they sort of interfere with either discriminatory or interfere with the right to a family and so on. I found that the arguments in those sort of cases extraordinarily difficult because it's, undoubtedly they all have been debated in Parliament. There's been a lot of political debate about, and then we're asked to look at them from a legal point of view. And I've always found it very, very difficult to draw that line. But, that's the job and one has to do it.
Thank you very much. I think that brings our event to an end. So if you'd all like to join me in thanking our speakers.